Someone make it make sense.
Probably a couple.
Hello, everybody. Welcome back, party squirrels of the world. Happy to see you. Happy Annie. And also, if it's your first time here, welcome. I know sometimes there's some of you guys you might be watching, or you might be in replay crew, or maybe you haven't left a comment or been in the chat, but I usually tend to recognize people's names, whether they comment in the comments or comment in the chat or chat in the chat. So, but if you're new here, welcome. And if you're not new here, also welcome. Welcome back. Happy to see you. So we are here to watch this hearing from yesterday with Karen Reed. And this was a very exciting hearing. I've been watching it in bits and pieces, so I can't say that I've seen every single minute of it, which is great, because you're going to be getting for a lot of this like a first reaction to a lot of this from me. I there was a lot of crazy moments. Some of these hearings are more exciting than others. And, the thing is that we're dealing with some potential Brady issues here, right? And, as I keep saying, we're barreling towards the trial starting here on April 1st. And there's new issues coming up. And this whole bit about the Lallyport video here, we call it the Lallyport video. Shout out to DSN for that awesome idea. It has been henceforth known here as the Lallyport in the Lallyport video. So a lot of questions about that. And also, speaking of Lally, we can see Lally over here on the right-hand side doing his best impression of courtroom furniture. Every now and again, I hope somebody checks for signs of life. But what if anything is Lally doing? What if anything is Lally saying? That would be nothing. From what we can tell. So without further ado, we'll kind of jump right on in here. And by the way, I'm so excited to see Alan Jackson, right? He's not been too involved in the recent hearings. When I first saw him there, my head went to, as he's standing there quietly, my head went to like, I'm back, baby, like with a bunch of Y's at the end. Like, here he is. He's been waiting for his moment, right? Shout out to Candace also. Happy to see you again. So it was awesome to get to see what he's been sort of gearing up towards. It seems like as well that potentially he could be arguing the motion to dismiss, since there's an overlap here with these expert related expenses. And then of course the lack thereof of the Lallyport video. And that would make sense why Alessi's been doing a lot of the arguing at the previous hearings. So, delegating, always important, always a good idea. Teamwork is dreamwork, as they say. And also, I will say, too, one thing I thought was really interesting is how is Brennan's involvement. But we'll talk about it when we get there. So, okay. DSN, I just gave you a big shout out, my friend. Happy to see you. Squirrel Free Night is right. Heck yeah.
To save me time, does your expert in his affidavit say that this information was erased or that it wasn't there?
It wasn't there.
Okay.
It was erased by an operation of automation.
But do I bother reading your expert's affidavit again so it's not in there?
And I'll address what our concerns are in my oral statement.
All right. I hear you.
Ma'am?
Yes.
The court started by asking what is it that the defense is asking for? Basically, we're asking to be.
So they plowed right on into this. No foreplay, as it were. No hearings. I mean, kind of interesting. This is a certain feed that if you guys see the square in the bottom left, you guys probably know which feed this is, because y'all know they're notorious for, getting pissed at people for using it, even though it's public information. But anyway, I doubt they would have cut off the hearings, because those are so quintessential to the flavor, as it were, of this of these proceedings. But yeah, they just sort of jumped right on in.
Be
So
treated equitably and fairly. This really is an issue of equity, an issue of fairness, and the court maintains the inherent. This court maintains the inherent authority to issue sanctions when there is an injustice. And those sanctions can include something like cost-shifting sanctions. And there's a body of law that exists that deals with this exact thing. And that body of law includes the case of the Committee for Public Counsel Services versus the Attorney General. That's at 480 Mass 700. It's a 2018 case. The court may remember what was, I think, pretty widely known here in these parts, which was the Amber scandal. Had a bunch of cases going back from 2010 all the way through.
I'm very familiar with the case.
All the way through 2018, and it culminated with Justice Gaziano discussing in his opinion, single justice opinion, exactly these types of things.
But just real quick, because they just plow right on in. So for anyone who's like, what the heck is going on? So they're talking, it was kind of unclear to a certain extent what they were going to be discussing today. Yesterday, but we're watching it today, because initially this was going to be reserved for a potential date for the Daubert hearing. Now we know that wasn't happening. And so it's sort of my guess was like, they're probably going to be talking about this motion to recover the expert related expenses. Sure enough, that is what they're talking about. And for anyone who's not sure what I'm talking about there with that is when the defense sent their expert all the way from Arizona to go out to Canton and view this potentially, they thought, okay, according to them, definitely view what was there of the Lally Port video, right? That's been inverted and coming out in bits and pieces, and people are disappearing like ghosts and all that, right? And so they spent all this money, right? And then, $12,200 or something. And then they go out there and then they're like, the law enforcement is like, oh, it doesn't exist. We've covered all the filings related to that and everything. And so in that, the important thing though, from that defense filing is that they mentioned, and there will be a subsequent filing and hearing for a motion to dismiss, as in the indictment, right? As in, this is so egregious. There's prosecutorial misconduct. There's destruction of evidence, right? And so that will be forthcoming. I think some of those due dates are next week, but we will hear that when they get to scheduling. So this is sort of a preamble to that. So in other words, there's like two issues there, right? There's like the first thing is we wasted all this money, the Commonwealth needs to pay for it. The second thing is the fact that this video is not there and we can't do anything with it. And, this is the crucial piece of evidence in the case, right? That, that's where they got the motion to dismiss the indictment. So we're here on the first element of that, which is recovering the expert related expenses. Now, all that to say that everybody's opinion thus far has been, this is a no-brainer. It's $12,200, right? The Commonwealth needs to just pay it. Like in any other situation, the Commonwealth would just pay it. Like, how can you even say we're not going to pay it? Like that has been the attitude that everyone commenting on. And of course, that just makes sense, right? It's like, if indeed the Commonwealth, had represented, like, okay, so let's say that Hank Brennan, right, had represented to, and we're going to get into the nitty gritty of this, but the understanding is if Hank Brennan represented to the defense, saying this video is going to be there, you can come see it. They go out there, law enforcement's like, we don't have anything, blah, blah. It's like, okay, so they were, whether it was Hank Brennan's fault or not, right? Like, in other words, law enforcement could have given him the wrong idea. There's all kinds of fuckery potentially, right? And who's responsible for it is another whole thing that they're going to talk about. But if indeed somebody gave the defense that idea, that the video, you can come see the video, and then they get there and it doesn't exist, right? The defense expert, then yeah, they should be held accountable for wasting the money, right? So part of what they're going to be talking about is like who knew what when and what are the exact circumstances. So that's just all to sort of set the stage. But again, going into this, the overwhelming, I don't think anybody even said to the contrary. Obviously, the Commonwealth should just pay for it. Like what? Like almost like, why are we even having a hearing about this, right? Just pay the money, right? But nothing is ever so simple in this case, right? So
what Justice Gaziano said was, quote,
I am happy to see you again.
That the court has the authority pursuant to Rule 14, sub C, sub 1, to impose remedial monetary sanctions for a discovery violation. And he cites Commonwealth v. Firth, indicating that sanctions may be imposed under Rule 14 for failure to comply with discovery obligations, and sanctions should be tailored appropriately to cure any injustice resulting from a party's non-compliance with its discovery obligations. So the real question before the court today is, and really the only question before the court today is, has Ms. Reed suffered any prejudice based on blatant discovery and Brady violations by the Commonwealth? And the answer to that question is a resounding yes, she has. Your Honor, Ms. Reed, as the court knows, is on trial for her life, and she's been expending precious resources for some 3 years now, defending herself against provably false allegations. And at the center of that storm of defense are the Lally Port videos.
Lally Port.
It should be pretty straightforward, really. I mean, it's just a series of videos at a particular location.
Right. That's what I was saying, right? It should be pretty straightforward.
For a particular time, and that time is January 29th, 2022, from midnight until 11:59. It's a 24-hour period, 23 hours and 59 minutes. It should be pretty simple, but it has been anything but simple in this case.
Literally exactly what I was just saying. That's fucking hilarious. When I was like, yeah, this should be straightforward. This should be simple, but nothing is ever so simple in this case. I think I literally said simple. Wow. Well, that's kind of a squirrely crystal ball moment. So let's roll that real quick. Love it when that happens, guys. Hang on. Let's enjoy our moment with some magical squirrel in here. So magical.
We've been asking for a full download of every single one of those cameras and all that footage from January 29th, 2022, from 12 a.m. to 11:59, but we've never gotten it.
When did you first seek it?
We asked for the preservation on February 2nd, 2022, when Mr. Yannetti said, retain and maintain all physical evidence. We've been seeking these videos since well before the first trial. We didn't get them before the first trial.
Do you have a date? Do you have any chronology for me?
I don't. I can certainly provide those, but it's been.
I'd like that. I mean, that would be.
I'll be happy to do that. It's in discovery request after discovery request after discovery request. Basically, there's also a catch-all. We've been asking for all physical evidence concerning video footage from Canton PD from well before the trial. We didn't specify which cameras because we didn't know which cameras had
that makes sense.
footage. We didn't know how many cameras there were. But we didn't get anything.
They can't be more specific because they don't have enough information to be more specific. Think back to like with BK, for example, right? This is just a similar concept where in the, with the search warrants, right? One of the things is they have to be as specific as they are able to be in the moment. So for example, you can't just be broadly, and again, I'll just say it's different because here it's the defense requesting evidence versus a search warrant via law enforcement, but similar idea, which is, for these different standards, right? Part of the thing is like, how specific are you able to be at the moment with what you know then? Because as you know more, you can be more specific. Similar idea here where they don't know, they first get on the case, right? And so like all physical evidence, all video evidence encompasses, right? Obviously these different cameras because they don't know how many cameras are there, etc. So.
From the Commonwealth. And I'll address
that. You're not alone there. Bev drives you nuts. Yep. I think you're in good company with that sentiment.
In just a second. Mr. Lally didn't give it to us before a full download, before the trial. The Commonwealth didn't provide it during trial. And today, as I stand here, we still don't have it. And interestingly, Mr. Brennan does make mention in his opposition that, quote, at no time has the defense ever made a formal preservation request. I found that interesting for two reasons. I have two comments about that. First, as the court record reflects, on February 2nd, 2022, I just referred to it, Mr. Yannetti filed a preservation demand for, quote, all physical evidence to be maintained.
There you go.
That DVR, the footage on the DVR, is physical evidence that was required, not requested, but required to be maintained by the Commonwealth pursuant to that demand. But second, and this is probably more important, it wouldn't have mattered if we didn't ask for it to be maintained. It wouldn't have mattered if we didn't ask for it to be preserved.
Agreed.
This was a self-executing duty by the Commonwealth. As Justice Gaziano stated in the same case, the Committee for Public Counsel, quote, a prosecutor's core duty is to administer justice fairly. To fulfill that duty, a prosecutor is required to turn over exculpatory evidence to a defendant without regard to its impact on the case. The failure to disclose evidence favorable to an accused that is material, either to guilt or to punishment, is a violation of due process. Litigation strategy plays no role in this process. Under our rules of professional conduct, a prosecutor is required to make timely disclosure to the defense of all evidence or information known to the prosecutor that tends to negate guilt of the accused or mitigate the offense. And he cites Massachusetts Rule of Professional Conduct 3.8 subsection D. The Commonwealth's Brady obligation is self-executing, Your Honor. It wouldn't have mattered one whit if we didn't ask for that footage, but it turns out that, in fact, Mr. Yannetti did ask that it be maintained. And the Commonwealth has still failed to preserve it. What we have gotten, it appears, are scraps and fragments of videos that the Commonwealth has decided on their own, within their own time frame to dole out to us over the course of months and years. And included in that scrap and fragment was a video that was missing 42 minutes. The court is well aware of this video. It was heavily litigated and heavily referenced at the first trial. That's the exact time frame.
Yep.
The missing portion is the exact time frame that the SUV was being pulled into the Lally Port.
I'm sure you guys are with me on this. I was so shocked as to how that was not a bigger deal the first time around. Like what? I mean, I don't know. And also I'm trying to find, goodness gracious. I know there's already been a ruling. I'm not going to say what it is in case any of you guys haven't heard it yet. I don't want to be a spoiler alert. But there has already been a ruling on this motion to recover expert-related expenses, and I'm trying to find it. And I think maybe I just did find it. So we will go, oh, yep, found it. Okay, great. Never mind. So we will go over this at the end of the hearing. Okay.
We got that video on April 4th, just days before the first trial. Keep in mind, it's a video from January 29th, 2022. Another one of those videos was the inverted video that has now seen some fame.
It has seen some fame. That's accurate.
The jury is a true and correct copy
Yep.
of the video within the Lally Port.
Yep.
And we got that one after the trial started, in the middle of trial.
Yay! How are you feeling since a couple hours ago?
Videos from January 29th, 2022, 2.5 years later. And why were some of those videos altered or manipulated and not in their proper
$1 million
form?
question.
We still don't have answers to those questions.
It's fucked
And
up.
literally, while we're asking that question and while we're pondering that question, a couple of days ago, we're getting yet more videos.
This is the crazy
Scraps,
part.
Piecemeal. We got another Lally Port video just a few days ago. This one showing the Lexus backing into the Lally Port from some exterior camera. And that also is exculpatory evidence. Mr. Brennan writes in his opposition that the idea that the defense has been misled or was misled in its efforts to try to go secure that DVR footage is a distortion of the facts with, quote, no legal merit. Really? A distortion of the facts with no legal merit? Where's all this footage coming from, if not the DVR? It's the only place it was held. It's the only place it was captured. So of course we were misled by continually getting these piecemeal snippets of footage from the DVR, from the very source. Had to have come from there, coupled with the Commonwealth saying, and Mr. Brandon saying, yeah, come on out. You can have your expert come out. Meet us at Canton. We'll provide the DVR. You can have him look at it. He can bring his equipment, download whatever you want from that 24-hour period. So what were we to believe? That it was on the DVR. It had to be. How else were we getting these piecemeal videos?
Yeah.
And they've had that DVR for 3 years. They knew exactly what was and what was not on that DVR. They had to have. This has been the center of a storm that surrounded this case from the jump. And to claim otherwise, it's just patently absurd.
So the girl in the back row, I bet you're talking about this girl that we've commented on before. I can't see her right now, but you're probably talking about, it's got to be the same girl. There was a girl that we were watching, or we commented on at the last Karen rehearing just from a week ago or whatever, that, like I was saying, actually looks a lot like Karen's dad. And apparently it's one of Karen's friends. That's what Need Some Z's said. But I'll keep an eye out if it's the same girl. But yeah, for anyone who didn't hear, I just grabbed that, the order on this. So Meg has had walking pneumonia, and I hope that you're right. That's who it was last time that I thought looked just like Karen Reed's dad. In fact, I paused it. There was a side-by-side and their noses are like identical. So I could see someone thinking it looks also kind of like Karen because it looks like her dad. And Karen looks like her dad. So, but yes, but Meg has been sick. So hopefully you're doing better. I know earlier today I asked you the same question. Yeah, I also love Ajax. He's like, I'm back and better than ever. So I had something else I was going to say too. What was it? Well, I guess just that the mystery is going to deepen with this whole thing of where's this video coming from. So it was very fun. It was very fun. Scott's referencing, for anyone who missed it, the us watching Wendy Adelson from Katie McBenowa's retrial. Honestly, it was so good. I kind of want to watch it again. It was so good. Honestly, it might even be better than her interrogation because you can see her face better. And there's a lot of the same kind of nonsense, but like the fact that she gets destroyed on both direct exam and cross exam is just so nice. And it's like better than anything, really. It's like really, I don't know, probably worth watching again, I would say. So Candace saying, yes, it was great. Yep. Oh yeah, definitely, for sure. And I can only imagine how much worse that got after this hearing when Judge Bev, well, again, I'm not trying to give any spoilers.
So Mr. Brennan also wrote in his opposition that Mr.
By the way, for anyone who hasn't seen it, go to the Discord and go to the Squirrel Crew, which is like one of the threads, me and DSN have been going back and forth with these Wendy memes. And honestly, it's my favorite thing in my entire life. I'm sure they will continue. And my thought is whenever she finally gets arrested, we're going to have a whole thing. Part of what we'll do is we'll do like a presentation with all the different Wendy memes, on the stream so everyone can see. But there might even be another one since I last checked. But for anyone who wants to see the hilarious Wendy memes, go to the Discord. I'll have Nightbot put a link in the chat. They are fucking brilliant. So yes.
Said, don't touch the DVR, don't mess with it. So I informed Chief Rafferty, tell your staff, don't touch it, don't mess with it. Almost intimating that it's my fault that we didn't know what was on the DVR. That's absurd also. How am I supposed to know what is or isn't on the Commonwealth's DVR?
Okay, so I think the lady you're talking about, Scott, I don't think that's Etsy. I think I see who you're saying looks kind of like Karen Reed, but that's a different lady than the one that we were mentioning because the other lady had much blonder hair. So I don't know who that is, but she does look similar, but that's not her. She's sitting in
sort of a liberal interpretation of the facts. What I actually said was, Mr. Brennan, do me a favor. If we're going to come out there, just don't have anybody download it in advance. Let's do it all together when we're all in the same place. That's what I said. And he accommodated that. He said, sure, we'll agree to that. So based on this history of getting these small clips from January 29th, we knew there had to be more footage. So when Mr. Brennan came on board, we made the request to him as well as the requests that we had made to his predecessors. We want all the footage for that 24-hour period. And lo and behold, we started getting more clips, more snippets, more piecemeal bits and bytes from that DVR. And one of them was a clip of Brian Higgins standing out in front of Canton Police Department in the parking lot in the freezing cold at 1:35 in the morning on January 29th on his cell phone.
Right. Brian Higgins. When I came into this to cover it, right, I knew literally nothing about it because I stayed away, like run away, Monty Python. But I stayed away because of the toxicity and whatnot. And then as some of you guys may have heard, I inadvertently caught some of the opening statements from Mr. Unetti. And then I was like, all right, we're covering this. And so knowing nothing about it and just kind of watching it as it was happening and not doing any reading or whatever, just forming my own opinions and looking at the evidence and whatnot, my first thought in terms of the head injuries to John O'Keefe, which I inadvertently, accidentally ended up seeing, without knowing anything else at the beginning, knowing that there was something about a snowplow, right? And that was coming in early in the trial and the pictures. My first thought was that the head injury looked like it could have been from the blade edge of a snowplow. Like, how it's curved and then it has a sharp edge on top and at the bottom. And one of my thoughts was that, like, if he fell backwards, John O'Keefe, if he fell backwards or if somebody pushed him, either way, and hit his head on that snowplow, that's just kind of what it looked like. And there were also questions about the visibility that night. And I think there were questions to Brian Higgins about that as well. Like when you were driving your snowplow, did you have your lights on, stuff like that, which again, at that point in time kind of hinted at, could he have been hit by the snowplow? Like my first thought was maybe he was just standing there and like fell over, but almost that sort of was hinting those questions were like, did Higgins accidentally hit him because he was so drunk, right? That was the first thing with Higgins. And then Higgins going to the Lallyport and all that. And, I had a thought at the time right away when Higgins was talking about how there was some young cop who was there in charge of the surveillance camera. And he was asked a simple question, like, was someone watching the surveillance or something like that? And it was one of those answers where it was like way too many details. And one of the details was he had to throw in there that this was somebody who was brand new and he'd just been promoted to be able to do that and blah, blah. And right away, without knowing anything else, I was like, oh my God, there's going to be something wrong with this footage. There's going to be something wrong with this footage. This is weasel alert, all that. I was like, don't even tell me. Like right away, I knew there was something up with it. And like Brian Higgins kind of went by the wayside as the trial went on, because then you had the fuckery of like Trooper Proctor and all the other stuff, right? There was just so much. But anyway, I'm just reminiscing about Brian Higgins because he was a big factor in this whole fiasco early on. And again, kind of got outdone, if you will, in terms of the fuckery once Trooper Proctor took the stand, and then it was all about Trooper Proctor. Yeah, so that snowplow, so that was Lucky. So yeah, Lucky was great. I'm talking about Brian Higgins because he had he drove, he had a plow. Okay, sorry. It was a Jeep with his plow on it, right? Not a snow plow. So a Jeep with the plow attachment on it, right? And that whole thing didn't make sense, right? Because remember, guys, there was like not enough snow. It was like not, that was part of the whole thing, was it was like, didn't make any sense that he would be driving the Jeep with the snow plow attachment when it had only just started snowing. And there was some other weirdness as well that I pointed out too, with the order of how people arrived at the house and then the parking. Like, if I remember correctly, Brian Higgins got there first, but then there was some shenanigans with moving the cars around. And I looked at the details, we looked at the timing, and there was things that weren't adding up with that either. And who went in the door when. There was just a lot. I mean, basically none of it's adding up, right? But yeah, it was the Jeep with the snowplow attachment. Yeah, I didn't mean to implicate that Lucky did anything wrong. I'm talking about Brian Higgins. Thanks, Meg. You're wrong. Quoting Brian Higgins. Okay, Colin. God, Colin was also, God, was one train wreck after another. That's why Brian Higgins got overshadowed, I feel like. So you also thought it was a snowplow blade. Jen, it has to be a banshee voice. I try to do. Jen. Yeah, Lucky was awesome, but that's not. Hi, twins. Happy to see you. Yeah, I'm referencing though Brian Higgins with the snowplow on his Jeep. Lucky had, I mean, he was great. But I remember them asking Brian Higgins, like when you started your Jeep, remember they were asking about the windshield wipers? Like, did you have your wipers on? Were your lights on? There were a lot of questions about that again, at the time I was already thinking head injury looked like it could have been from a snowplow. I'm not, just to be clear, I'm not talking about Lucky. I'm talking about Brian Higgins, right? And then that was, and I thought that before, and then they asked those questions about, again, like the windshield wipers and the lights. And I was like, is that what the defense thinks maybe happened as well? Scott says, I wonder how many people Colin has beat up since the trial asking for a friend. Love it. You guys are fucking hilarious. You guys are so funny. Twizzy and Dehizzy as well. Twiz, did you check out that latest map I sent you on Discord? But welcome. Right? That's hilarious. So you're on your phone, not your laptop? I'm guessing from context clues. Speaking to Twiz there. Okay, let's keep going.
To punctuate the importance of that video footage, recall that this issue was raised.
Meg, do you want a custom? Sorry, hold on. Meg, do you want a custom command? And also Scott, anyone else who's here on the regs, do you want a custom command?
Extensively. When I say we, both the Commonwealth and the defense, me in particular, spoke with Mr. Higgins about this issue. It was raised at trial, and Brian Higgins never once, not once, on direct examination or on cross-examination, admitted to having made a phone call in the middle of the night on January 29th. And yet now, after the trial, we get a video of him doing exactly that. And that also proves that he lied in front of a federal jury. I'm sorry, in front of a federal grand jury, when he testified that he didn't have or make any phone calls in the middle of the night.
Now that is a big fucking deal, right? Because lying in front of a federal, well, any grand jury, but I mean, it begs the question, right? Everybody knows that that's bad news, but especially if you're a law enforcement agent like Brian Higgins is, then A, you also, even more than your average person off the street that that's bad news, but B, that the repercussions for that are going to be even worse for you. So one has to think about this. What is it that Brian Higgins wanted to hide in regards to these phone calls that was more important, right? And more worth, like when you think about your cost risk analysis, like more important to keep secret, right? That it would be worth lying to a grand jury and also on the witness stand. Like the other thing is a bigger deal. One has to think about that, right?
That is called exculpatory evidence. And that's Brady evidence. And it was withheld in its entirety during this first trial
Yes,
and for the next 3 years. And
oh my God, y'all are funny.
I bring that up, Your Honor. It's against that backdrop that we then say to Mr. Brennan, kindly give us the footage. I don't want this piecemeal thing to keep going on. Just give us the raw footage. We'll send an expert. So the plan was put in place, and experts were retained, and flights were booked, and hotels were reserved, and transportation was arranged, and all at Ms. Reed's expense. She's writing the check for all of this. And our expert flies out to Canton, walks into the room, and within 10 minutes, they open up the front plate of the DVR, and lo and behold, the Commonwealth says and agrees, oh goodness, there is no footage. It was overwritten.
Surprise, surprise.
What? How could that possibly be? So the expert calls me. Mr. Jackson, what do you want to do? I don't know. I'm not a tech. That's your job. I don't know what to do.
I'm sorry, Mr. Jackson. Ooh, I am for real. You know, Outcast, Miss Jackson, but Mr. Jackson.
If it's overwritten within 30 days, I don't know. Maybe there's a log. Let's find out who has access, whose digital fingerprints were on that DVR, who downloaded the footage, when it was downloaded. What about these clips that we have? I'm very confused.
Mm-hmm.
So the expert goes back and says to the technician for the Commonwealth, Colleen Crawford, well, let's at least download the log. At least we can have access to that and start unraveling what's going on here.
Okay, since he's at the end of a sentence, I'll pause it just to okay, so Meg P wanting the story, because I'm not sure who all's heard it before or not, but I seem to get the story right every time I tell this story about DSN and the story behind the name, right? So there, if you look at the picture there, so there's the picture. So the story behind this. So this was during COVID, okay? And and every time I tell the story, I always double check DSN. Am I getting it correct? So same goes here. So it was COVID, and so the kids were doing school from home or whatever, right? And so they had like a show and tell type of thing. And so DSN's young son, first grade, was it? Maybe kindergarten, first grade. Anyway, I'm sure he'll let us know in the chat. But he was doing show and tell. So that picture there, right, is a vintage, authentic, like G.I. Joe action figure that belonged to DSN when DSN was a child. So DSN's son, like, it's his turn, and he has this action figure, this G.I. Joe, and you know, the teacher or whatever is like, oh, and what's his name? And just out of the blue, DSN's son says, Daddy Shortnuts. So that's the story behind the name and the picture. Yes. Kindergarten. Thank you. Over Zoom. Excellent. Kindergarten over Zoom. There we go. I don't know the answer to that. Can anyone submit someone? I don't know how anyone, like, if they're not an interested party, I don't know how they'd be able to do that. I would imagine they have to be an interested party, you know, like, that would be a good question for Denise, but just thinking it through logically, I can't imagine that like any random person can just be like, hey, get on the Brady list, right? You know, you have to be an interested party, which if it's a criminal case is going to be the defendant or defendants, plural, if there's more than one, and the government. So, but now you guys know, you have the story, DSN.
Oh, sorry, that's been overwritten as well. There is no log. You get no footage, you get no log. This was a complete and utter waste of time. According to the Commonwealth, that system, as I said, overwrites every 30 days. So by February 28th, I counted them. By February 28th,
Fisher Price, thank you.
Every single frame of that footage should be gone.
Thanks, DSN.
So how did we get the inverted video in April of 2024? How did we get the video clips of Brian Higgins in October of 2024? How is that possible? The only explanation, Your Honor, is that the Commonwealth downloaded the entire system within the first 30 days. Otherwise, it's gone.
Right.
Admittedly.
And so
And all of that has been withheld from us for 3 years. Then to add salt to that wound, the Commonwealth allows us to go on this wild goose chase, spend $12,000 some odd dollars of Miss Reed's money, and fly an expert out to Canton for absolutely no reason. Zero. The 30-day overwrite protocol is something that their technician absolutely would have and should have and did know before we ever set foot in Canton.
Knowledge.
She was well aware of exactly why we were going out there. We were going out there to download footage from 3 years earlier. She knew it. We knew it. Mr. Brennan knew it. Everybody knew it. But within 10 minutes of walking in the door, it was revealed that there, in fact, was no footage. And that's a fact that the Commonwealth had to have been aware of for the last 3 years. Yet Karen Reed is the one having to foot the bill for what turned out to be just a snipe hunt. It's not fair, and the Commonwealth should reimburse her for this fool's errand that was not of our making, of her making. The Commonwealth has since told us, Mr. Brennan told us that remarkably, he went to Canton PD, and this is in his opposition paperwork and his declaration, and he spoke with some officer. And that officer told him that he, the officer, personally made a copy of the entire January 29th video footage and placed that copy in some sort of an iCloud account. Not on the DVR system.
This is
not in the official data bank in which it's supposed to be stored, but on some iCloud account. And we're finding out about this in 2025. It's outrageous. What it is this entire situation surrounding this DVR and the Commonwealth's maintenance of that DVR and the footage on it is a complete dumpster fire. And Ms. Reed has to pay for the fire extinguisher.
So that's the quote that I have on the thumbnail. But let me show you guys something real quick here. Thanks, Meg, for your question. So a couple things. Let me pull the banner down. So I did not, I guess maybe I knew, but I forgot. Oh, let me make it this other thing. Okay. Brady v. Maryland. It's like, I knew that, but I didn't anyway, just, isn't that crazy? So Brady, of all the things, right? Brady was a Maryland case. So, okay. So here we go. Some law enforcement agencies compile lists of names in an effort to track various forms of misconduct. Prosecutors use these lists to determine blah, blah. But here's the thing. So practices vary widely throughout the country. Presently, there are no Massachusetts procedural or substantive standards for inclusion on a Brady list. Ironic, considering that this came from a Maryland Supreme Court case, actually, or sorry, a U.S. Supreme Court case, but Brady v. Maryland. Jesus, wait, hold on. I'm getting my M words confused, Maryland and Massachusetts. Anyway, but this is still the case, right? So presently there are no Massachusetts, right? M words. But, really, Massachusetts? So these cases don't mandate the creation of any such list and don't even reference such a list. In both cases, the court addresses the conduct of a prosecutor, not a police officer. So this is Massachusetts, though, which is good, specific to the state. So if it does not maintain a list, what does the DA's office disclose evidence? Does the DA's office disclose evidence of police misconduct? Yes, in some cases, they might take unilateral action by dismissing a case if the evidence of misconduct or reliability is manifest. Such disclosures are handled every day on a case-by-case basis. Why doesn't the DA's office simply keep track of all disclosures in the form of a list? Creation of such a list would be impractical. I'm shaking my head. Okay, so it's here. So this is interesting. Such disclosures are frequent because reports can be written many years before trial. Memories can fade. This is not misconduct, but it must be disclosed to the defense. So it sounds like things might be disclosed to the defense as Brady, but not make it to the list. So I'm still trying to find the exact answer, though, to your question, Meg, about who can submit. But again, I still think it would have to be an interested party. And just from a cursory look, it's the prosecution that submits things to the list, is what it says generally. But I'll keep taking a look, but I just wanted to show you guys what I found there.
And that's not fair.
That's not fair.
The High Court and the Committee for Public Counsel, the same case that I referenced a little bit earlier, and the court will know this because this was sort of the big takeaway from that case is Justice Gaziano fashioned a cost-shifting remedy against the Commonwealth and for the defense. And that included the entire cost of investigating and locating and contacting nearly, I think it was 10,000 defendants. It was an enormous amount of money and an enormous undertaking. And the Commonwealth had to foot that entire bill. And the reason they had to foot the entire bill is because the Supreme Court decided that it was prosecutorial discovery violations and cost-shifting remedies were in order. We're asking absolutely no more than that from this court. Fairness dictates that Ms. Reed be reimbursed. And I'll submit, Your Honor.
All right. Thank you very much.
He's submitting. Yeah, again, I'm doing some more. It does look like prosecutors are kind of in charge of maintaining that list. So. All right, now we're on to Commonwealth.
It's notable that the defense purposely conflates two very separate issues. If you had a chance to read their motion, they suggest that they should receive costs because they hired an expert, came to Canton, and didn't receive the information they wanted.
Big shout out to you, Mass Dad. Yes, that's exactly. I was actually just reading that. I think you may have. But yes, thank you. You've got boots on the ground. No DA's office in Massachusetts is required to. Thank you. Oh, Bill Thompson. Oh, thank you. I was like, BT. It gets confusing with so many initials. Thank you for that, Mass Dad. Also, welcome back. Happy to see you again.
Yet today in the argument, they try to give you a historical complaint about the production of videos in this case. That is a separate issue. That's a Rule 14 issue, but that is not the motion before the court. The reason I suggest they conflate the issues is because they know their merit for costs. I mean, their motion for costs has no merit whatsoever. And so what they're trying to do is incite facts, invoke this injustice they've created so that the court looks at the motion that they actually filed and gets it distorted. it is disappointing to stand before a court and file an affidavit as an attorney and have someone else have a cross affidavit. Frankly, in my career, when that has happened on rare occasions, I find that embarrassing. There is very skilled and able attorneys in this courtroom, and to work out discovery matters and agreements is something that attorneys always should do. And that is what I've tried to do in this case. I have tried to give the defense the best opportunity I can to get whatever information they want, whether it is required or not required.
Okay, a couple things on this. So I've said along the way since the first hearing with Hank Brennan, right? We saw him before we met Mr. Lessie. And he said, you know, we were like, okay, here he's the new face of this case. Lally's just relegated to furniture. And, you know, I'm not alone. I think everybody, myself included, really appreciated how he really seemed committed to turning over discovery. There was, the thing about all the transparency and we turn it over. And that makes sense considering he is a defense attorney, right? And it's like, if you're a defense attorney, right, and then you are in this role as a representing, a special prosecutor, and you want to get on the good graces with the defense from the beginning, it's like turning over discovery is a good way to do that. Of course, it's required, but sadly, we see so much fuckery in all these different cases regarding discovery that it sadly is full transparency about turning over discovery is quite rare. And so that is a good thing, right? That's a good way to start. And as I've been saying all along, I've been saying it seems like he's making good on that promise, because if he wasn't, and I'm being specific when I say Mr. Brennan, right? Because you've got Mr. Brennan who's representing the Commonwealth, but then you also have like the DA's office, right? And the previous prosecution team, which is just sitting there in silence. And then you also have the law enforcement, right? So I've been saying it seems like Mr. Brennan is making good on his promise, because if he wasn't, you better believe we'd be hearing about it from the defense, right? So I think that that's important as we listen to the rest of this hearing. And, what is Mr. Brennan's responsibility versus what was already fucked up due to Lally, essentially, really, and also law enforcement, right? Because you've got all these different layers of issues. But what I can say is it does seem like, at least so far, while Mr. Brennan is maybe making a lot of really, offensive arguments, like we've seen that a lot recently, and being real like sassy and, maybe exaggerating things and whatnot, at least it seems like thus far he is still turning over discovery to what he knows, coming in here late and possibly being also misled himself, right? Because again, if he wasn't, you better believe we'd be hearing about that a lot more. But that's just sort of, again, preliminary thoughts as it pertains to the turning over of discovery.
Yet, I'm standing here today, and I have to now share with you my conversations with the defense.
Yeah.
I have to share with the court my position, which is...
I agree. So Mastad saying Brennan is one of the best defense lawyers in the state. Yes, he gets paid $1,000 per hour his work. He's out, right. And that again speaks to the fact that he was handed a shit case with full of issues that you could be Gandalf, and I don't think you could make this go any better, right? You know what I mean? There's just, the case is what it is, and how evidence was collected, for example, in red solo cups, you can't change that, right? And you can't change the fuckery that went on before. So I totally agree. And that's the thing. It's clear that he is a very skilled lawyer. We know that he's been involved in a lot of other high profile cases. But it is interesting. The question that I would have is why he took it on, but maybe he didn't have all the evidence. I mean, we remember from back to that first hearing when he made his first appearance, he was like, I'm still getting to know the case. I'm still looking things over. And perhaps he didn't quite know just how bad it was. I don't know. But, he's definitely doing his best, right? It's like trying to make a car win a car race. Obviously, I don't know NASCAR. I don't know, a car, but it has no engine and no wheels and no steering wheel and, whatever else. I'm sure there's even better analogies, because this is even worse than that. Just as an example.
In the defense, because they have lodged
Definitely
a motion asking for money that they are not entitled to.
DSN.
If I stand back and do nothing and remain the dignity of the court, then what happens is...
Right, he took it on willingly. He took it on willingly. That's why it's even more... Right, he was... Why? Why would you take it on,
Nowhere. And a lie unchecked becomes the truth. So now I must stand before you, and I must tell you what happened.
Now, I do love that quote. Let's listen again. Honestly, this is something I always say, but this is putting it very succinctly. Well, Yep. MCAT sent. Yep. Echoing the same sentiment here. Why did he take the gig? Yep. I don't know. It's very odd. Hold on. Let's just see. Spinny wheel.
Motion asking for
Okay.
money that they are not entitled to. If I stand back and do nothing and remain the dignity of the court, then what happens is there are claims that just float out in nowhere, and a lie unchecked becomes the truth. So
I do agree with that. A lie unchecked becomes the truth. However, if he believes that, which I mean, hopefully he does, what about when you look at everything going on in the case for the common, like, you know what I mean? Like, he's saying this as it pertains to something as, honestly, when you put it into context, right? The significance of the lie unchecked becomes the truth. I agree with that sentiment. He's referencing that simply as in, like, did we promise there was going to be a video or not? How is that a bigger lie to address than all the other lies? I mean, one would hope that if he came into this position and got to know the case, right, and looked at all this and saw what was going on, well, like, one would hope that he would be like, this needs to be exposed. Like, this needs to be dismissed, but also the corruption needs to be, like, one would hope, right? Especially being that he's actually a defense attorney. One would really hope that on an ethical level, right? I don't know. It's tough for me,
So now I must stand before you,
Yeah.
and I must tell you what happened. When I entered this case in September and I began to look at discovery, I saw a video produced in August from the Canton Police Department, and we immediately turned it over to the defense.
Produced in August.
I began a study of the case and tried to articulate and account for all evidence and make sure the defense obtained everything that they were entitled to and more. The defense asked me to try to account for the video because they believed it had been an issue in this case. I looked through the docket. There was no motion to preserve videotape. I read the pleadings.
Again, that's not a valid argument. We already talked about why.
Attorney Yannetti was meticulous in his motions to preserve. It was admirable. It was meticulous, the work he did. There was no motion to preserve, and that has some import.
No.
It doesn't relieve the government of their obligation to provide Rule 14 discovery or exculpatory evidence or Brady evidence. It doesn't relieve the Commonwealth of their obligations to be dutiful, but it is difference in kind. Because the defense, if they want something that is not obvious, they put the Commonwealth on notice.
Yeah, so this is just not a good argument. So instead of, like, okay, there's two elements of approaches to what he can argue, right? One can be, oh, the defense didn't actually adequately ask us to preserve it. That's the other argument would be, we never said it was going to be there, or something along those lines, right? It's not our fault. So, or it's not my fault if you're Hank Brennan, right? Or it just doesn't exist, right? But we never promised that it did exist. That's a stronger argument, as we will see, versus blaming the defense, because they did adequately preserve it, and we already kind of talked about why. So it's interesting that he's going to lead with that, though.
Practice for almost 3 decades.
Mm-hmm.
You file motions to preserve within 24 hours, 48 hours, or 30 days. And so when Mr. Jackson called me, Attorney Jackson called me, and he said he wanted to come out and bring an expert to look at the NVR or DVR of the Canton Police Department, I had never seen that in 30 years. It's not part of our obligations. He's not entitled to come into the Canton Police Department with his own experts and download his request. But in the spirit of transparency and an effort to help the defense so there will be a fair trial and they can obtain all the discovery, understanding the history of this case, seeing that there was an August videotape post-trial, I wanted to do what I could to accommodate them. So without any hesitation, despite that there was no court order, no motion to preserve, I invited him to come to the Canton Police Department. I called the chief of police. I asked the chief of police, although this was unique and novel, unprecedented, could the defense come and access their material? Typically, the Commonwealth will download it and provide them a copy. She had no hesitation. So I called Attorney Jackson back, and I said that we would allow it. Attorney Jackson expressed concern, understandably, being a defense attorney, that almost 3 years later, the video may not be on the NVR. I had the same concern. I want all of the evidence. I'm not looking for evidence that's good for the Commonwealth.
Here's the thing.
Helpful for my
Right. Okay. So if that's what he said, what did he mean? Mr. Jackson, this is according to Brennan, right? Mr. Jackson expressed some concern that the video might not be on the NVR. That could have multiple implications, right? It could mean that Mr. Jackson is aware that things get deleted after a certain number of days, blah, blah. But also, regardless of that part, what that could have meant is that because of the fact that this video keeps coming out way after the fact in bits and pieces, right? Mysteriously, like right before trial, and then another one like during trial and whatnot. You can see how the obvious common sense thought is it exists, but it exists somewhere else. And so you could see how part of maybe wanting to go there and view the NVR DVR situation could be to try to determine, right, definitively it has to exist somewhere else. And then you go into trying to figure out where that is, right? Because you have to rule that out first. Now, however, if that was the case, if that was what they really wanted to do, then that is a problem for their argument in terms of recovering expenses, right? Like, in other words, if they were setting out to prove it's not going to be there, but it has to be somewhere else, that would be a valid purpose for wanting to inspect it, right? But that, again, would negate the argument as far as this whole motion.
Case, I want all of the evidence. And so after he expressed the concern, I made clear I had no idea what, if anything, was on the NVR. We could go and look at it, but Mr. Attorney Jackson didn't want that. He wanted his expert to be the person to open the NVR. And respecting his position, providing a professional courtesy, I agreed. I didn't mislead him. I didn't think there would be video. I had no idea. So Mr. Jackson, Attorney Jackson, pardon me, sent out his expert. And by the way, the expert that came was not the expert they designated. I got a call because we were in court on a hearing that they had sent a different expert they hadn't noticed. And my response was, it doesn't matter. Whoever they send, let them look at it. And so when they did, not surprisingly, the information had been overwritten. Now, while there was a 30-day overwrite on that machine, I believe the defense expert knows that there was a backup hard drive which kept materials longer than that 30 days. I do know that there were materials on that DVR, NVR, back in July of 2024, and I know that from a report that was generated by the Commonwealth and given to the defense, so they should know that as well. That may be one reason why they wanted to come out. They came out on their own volition. I extended the courtesy as much as I could, made no promises. I was clear, I was very uncertain about what would be on there since I never looked at it. After I learned there was no information on the NVR, I took the initiative and went to the police department. I viewed the police department, the cameras, I spoke to personnel, and I spoke to the retired individual who then
okay. Well, hold on.
Was responsible for providing video upon request. And when I spoke to him, he told me in conversation that he would routinely store a copy on a file he noted as a detective file or on his hard drive.
This is one of the parts, like I said, I haven't watched all this, but I heard bits and pieces. This is one of the parts that I heard. Like, I literally turned it on and it was like at this moment. And I was like, you've got to be kidding me. What the actual fuck? How is this possible? Because so many things. Oh my God. First of all, he's retired. So why is he involved? Second of all, he's not giving a name. Third of all, why is he making his own copies and then storing them at his house or whatever the fuck?
Department.
I don't even know.
I viewed the police department, the cameras. I spoke to personnel and I spoke to the retired individual who then was responsible for providing video upon request. And when I spoke to him, he told me in conversation that he would routinely store a copy on a file he noted as a detective file or on his hard drive.
No.
That was news to me. I thought that was helpful.
Right there, you've got an issue with chain of custody. If it does, like right there, right? That's the start of the issue. The issue, I can't even wrap my head around it. I don't even know. I've never heard of anything like this, so I don't even know all the implications. But at the very least, you have an issue with chain of custody. But you have another issue with if, in fact, this video only exists, right? This Lallyport video only exists on this retired nameless dude's hard drive and was overwritten and doesn't exist anywhere at the police department. If that's true, then why the fuck is this retired dude releasing bits of it at certain times and fucking with it? And like, what the fuck is happening?
Also, I notified the defense about my conversation. I was not trying to lure them back to Canton or have them spend money. I was trying to, as I always do, be as transparent as I could.
And that part I do believe. That part I do believe, because I believe a lot, like this, what it looks like is a lot of this fuckery, again, was before he came into this. You know, maybe when he was first looking at it, what he would have seen is a case that had a lot of issues. It's a weak case, blah, blah, but like, you know, if you are a good attorney, sometimes you can turn that around. But as far as the level of corruption, some of that shit might not have been apparent to him. And I really do believe that, I mean, what if you really knew it, you wouldn't take it on, right? Again, it's hard to believe. But it does seem like he's figuring out some of this as he goes along. And he's liable as well, right? As the new face of the Commonwealth. So
helpful as I could. Now, what I simply should have done and could have done is I could have gone to that detective file and downloaded the video and given a copy to the defense. That's my obligation, no more. But I didn't. I extended the courtesy that if they wanted to come and look at that file before we opened it, so it could be.
oh my God. YouTube's been doing this, by the way, for me, but also for other people.
Beyond reproach, they were invited to do that. I wasn't encouraging or luring them. I was inviting them because they'd already been part of the process. I thought it would be disingenuous not to let them participate. And what they told me is to wait. So now that information, whatever it is, I don't know because I haven't seen it. And I've asked the detective or the retired detective not to access it. It is sitting in that file, supposedly. So at this point, it's the Commonwealth's position that we are going to go and download that information to give a copy to the defense. The defense waited almost 3 years.
Yeah, totally.
The defense was very clear about my uncertainty would be on that tape. And now they stand before the court and they try to parlay this into some type of injustice.
Parlay. What are you, a pirate?
The case they cite, Commonwealth vs. Frith, the district court was overruled in assessing costs because there was no egregious violation. This is not a.
Hank Brennan, we had from the last time Hank Brennan had been watching too many World War II movies. We had grenades, we had missiles, we had all kinds of languaging. I can't even remember it all. They're all time stamped anyway. But now we've got parlay. So maybe in between he switched over to the pirate genre. You know,
this is not set up. This is the government providing information as the case progresses and evolves and changes and retools.
That doesn't make any sense.
What we have now is information supposedly in a database that we are going to get and give to the defense. You should deny their motion.
You didn't know about it, obviously. I mean,
they've taken a professional courtesy and an effort to help, and they've distorted it into some type of injustice.
And the thing is,
almost not going to be.
Is that it should have been made clear, like when the first time that the chunk of video came out right before trial, like that's when the Commonwealth or the Canton PD, so let's just say it's coming from this retired dude, right? And it's like magically appears on their doorstep wrapped in a bow or whatever the fuck, right? Like that's when someone should have been like, hold on, where is this coming from? And it should have been dealt with then, you know? And so the part of the problem is then you have, but instead of that happening, you just get subsequent video. Now it's inverted, right? And then you have more video coming out. What was it? Just in October or whatever it was that it came, or the defense got it of last year. And so now it's like, okay, now we're going to look into this and blah, blah. And it's just like, what the fuck?
Distracted from the cause in this case, which is a trial on April 1st.
I know. I was
distracted from the cause in this case. If they have a separate motion about Rule 14 violations or motion dismissed for misconduct, that's a separate motion. That's not the motion before the court today. The motion before the court today is to attempt to recover costs for something they chose to do and that I accommodated. It should be rejected.
In a way, I find that interesting. Did any of you guys find that interesting? Let me back it up. I do find that interesting because it's like, obviously the motion to dismiss is separate. Like this is a less bigger deal. Like that is such a understatement. Like this motion is a much less of a bigger deal than the motion to dismiss. But this is interesting what he says.
The cause in this case, if they have a separate motion about Rule 14 violations or motion dismissed for misconduct, that's a separate motion. That's not the motion before the court today.
That is interesting that he says that because it's almost like, how to put it? What do you guys think about that? It's almost to me, almost reads like he's saying that motion is going to have legs and he knows it, but we're not there yet. We're just here with the expert related expenses, you know, as if he's putting that in a different category. Like what how can I better articulate? Like he's saying, you know, his argument here is like point blank, this is not warranted. Reimbursement's not warranted. You know, this needs to be denied. But these other subsequent motions, like the motion to dismiss the indictment and prosecutorial misconduct, that's in a separate category. So I don't know. In a way, it almost sounds like maybe he's like expecting those to go somewhere. I don't know. What do you guys think?
Motion before the court today is to attempt to recover costs for something they chose to do and that I accommodated. It should be rejected. Thank you.
Any quick response, Mr.
Very,
Jackson?
very briefly, with the court's permission. By the way, it is a Brady case. There's no question that the data on those videos are Brady. They're exculpatory. That's where we start. So Mr. Brennan can say all day long, that's not a Brady case. Don't worry about it. Let's just sweep this under the carpet like we've done everything else. It's, there's nothing to see here. That's not true. It's a Brady case because the information that we have now received from that DVR, that NVR system, is exculpatory to Ms. Reed. That's why I cited
Brian Higgins part?
That's why I cited the Brian
Now
Higgins.
that
Correct. And I suspect there's a
is fucking interesting, right? Because really, that could have been referenced. The number of things that could be exculpatory in that video. There's a lot of it, right? Like, namely, at least initially, right? There was like the bit with the tail, the tail light and who's standing on the side of the tail light, and like none of that implicates Brian Higgins. Brian Higgins is the phone call, like. So my point is, like, with all the different things that could be considered exculpatory in these videos, the fact that Judge Bev says that is interesting because she doesn't usually ever jump in and say something like that.
else. There's nothing to see here. That's not true. It's a Brady case because the information that we have now received from that DVR, that NVR system, is exculpatory to Ms. Reed. That's why I cited
Brian Higgins part?
That's why I cited the Brian Higgins part. Correct.
Now, again, I'm going to elaborate on that, right? That shows, first of all, a look into what she sees as exculpatory. But why is that important? Well, because if it was just, let's just say something like the taillight wasn't quite as broken, right? Or any number of things, it wasn't clear who was doing what in the Lally Port, whatever. All that could be still Brady evidence, right? The difference to me, when she mentions another name, Brian Higgins, and him being on the phone, what's interesting about that to me? That implicates a third party right there. Like, not only is it exculpatory of Karen Reed, but it's potentially inculpatory of someone else. Like, this surprised me from her. But this is a huge deal to me because Brian Higgins, that's the whole thing with the third party. I mean, part of it, right? Like, that's why they brought him in the first trial, or, well, they didn't bring him in, but it was part of their whole theory, right? The Higgins and the Aunt McAlberts, right? That whole thing with the third party. And again, Judge Bev could have referenced any number of things that she found to be potential Brady evidence or exculpatory evidence in those videos. And the fact that she names Brian Higgins, again, that's just really interesting to me. What do you guys think? Yeah, surprised she said that. Yep. Jackson Rocks agreed. Like, I don't know. I would have thought it would have been more likely, even if Judge Bev maybe thought that, but that she wouldn't say it because, everything we've seen so far is so prosecution leaning, and that's an understatement. And like, this is really giving them like room to go with this. And I feel like Jackson's actually surprised as well. Let's back it up one more time so we can see, because I feel like he kind of pauses, and I'm going to put it on normal speed because I think he was surprised too. So let's just see here.
Exculpatory to Ms. Reed. That's why I cited
Brian Higgins part?
That's why I cited the Brian Higgins part. Correct. And
I mean, it's not like I don't know. What do you guys think? His brain works fast, so I feel like he's reacting quickly. But like, he doesn't just say yes. He says there's like, that's why I cited. Like, that's enough time, right? If you're quick on your feet, that's enough time for you to process that, and then because that you could be saying that's why I cited, and then you could put anything at the end of that. I don't know. What do you guys think? I just find it. I would find it hard to believe if he wasn't surprised by that because of how she's shot down everything from them, third party.
And I suspect there's a lot more on there as well. The inverted video part is also great, which we got in the middle of trial.
Mm-hmm. Yeah.
Mr. Brennan says, basically, his argument is,
Yeah, he's quick on his feet, but I think he was surprised.
They took a courtesy. I'm trying to be courteous. And he's a gentleman. This is not personal, Mr. Brennan. He seems to, the tone of his.
Now that I thought was funny. Did you guys catch that? I don't know if anyone else caught that, but I did hear this part again yesterday. Ladies and gentlemen, I wonder if he's getting enough sleep because there's no jury. Just spinny wheel.
Is, deny the motion because they took a courtesy. I'm trying to be courteous. And he's a gentleman. This is not personal to Mr. Brennan.
Oh, he's saying he's a gentleman. Never mind. I thought he said ladies and gentlemen. It kind of sounds like that. But never mind. Never mind.
He seems to, the tone of his
Hey, Abby.
responses was, well, this is personal between Mr. Jackson and Mr. Brennan. It's not personal at all. This is about the defense and the Commonwealth. It's about Ms. Reed and the Commonwealth. But let's not conflate a courtesy with an obligation. The Commonwealth has an obligation. I don't care that Mr. Brennan wasn't on the case previously for the last 2.5, 3 years. It doesn't matter to me. This is not personal to him. I appreciate the fact that when he came onto the case, he immediately found in August, he found a video that had never been turned over.
Mm-hmm.
I can't fault him for that. He turned it over when he found it, apparently. What I can fault is the Commonwealth.
I agree. And see, that's where, and to me, again, like I was saying before, he could be trying to really be like, this is Mr. Brennan's fault. This is, he did this thing and that thing. I think it's real. I found it really interesting that he really seems to try to make a distinction. And I think that's smart because I think that is, again, showing a spirit of cooperation and a sense of maybe not camaraderie, but, a defense attorney to a defense attorney, right? You know what I mean? You guys are both from that ilk, if you will. I don't know. But again, the other thing about it is by making that distinction, it shows that the fault goes way deeper than that and goes way back further than that. The fault is the Commonwealth. All this shit has been going on since before, any of it. And, the number of people who are culpable. And so it makes sense in that respect as well, to not just try to blame it all on Brennan, because that's just the one person. Again, he's representing the office now. He's the face of the Commonwealth, as I said, right? But the shit that's been going on happened way before he got there. And that is the bigger issue. And that's, I think, it's smart to make sure that is made clear as he's doing.
Mr. Brennan was brought onto this case not to represent Mr. Brennan, but to represent the Commonwealth. And all the foibles, all the warts and blemishes that preceded him, unfortunately, are now his responsibility.
Yep, there it is.
For the Commonwealth.
There it is. Yep.
He indicates that when he.
And while that might sound like a slight to Mr. Brennan, I don't take it that way. I take that as a compliment to Mr. Brennan, because again, he could be trying to throw Brennan under the bus here, and he's not. Like, that's huge, right? Like, he's not trying to do that. We usually see that in cases, right, where there's some sort of weaselness or fuckery happening with the prosecution. He's not trying to do that. He's making that clear. I think that's important, right? Again, defense attorney to a defense attorney. He's like, look, yeah. And Mr. Brennan said as much as well. He's like, I took this on. And so they're in agreement, right? And essentially, if you look at it, it's almost like they're in agreement that, like, the fuckery was way before he got there. Now he's kind of what is the right word? Guilty by association type thing, right? Now he's responsible for it. We all agree for that. We all agree to that. But, like, it was predating him, rather.
Found out that we wanted to come look at the DVR, and we had absolutely no right to look at that DVR. This was just a courtesy, etc. Well, that might be true if we hadn't made the request, because we had been getting piecemeal videos from a DVR system that it supposedly was overwritten.
So the oral request by phone call you're talking about?
The latest one.
Right.
So my request to come out and have an expert come out and see it.
I think
just
that's
a courtesy. That's just good lawyering on his part and mine.
He's right.
You want to keep your hands clean.
Yes.
Do it the transparent way. Have everybody come, bring their experts.
Literally, that's exactly what I was saying, right?
Whoever they might be, and let's download this stuff together. So there's no funny business, and everybody can wipe their hands and say, I didn't have anything to do with it except downloading material, and whatever that material is, it is. That's just good lawyering from courtesy. He was doing that to protect his own and the Commonwealth's interest, and it was quite smart until he realized, because he didn't have any way of knowing it any more than I did.
There you go.
That there was no footage. It had been overwritten. Perhaps, certainly the defense was deceived. Perhaps Mr. Brennan was deceived as well.
There you go.
That he contacted
right there. And that's the other thing, right? Because it's smart, right? It's almost like getting, like, they're in a way, it's almost like appealing to Mr. Brennan, like, hey, we're all on the same team here, right? We both were fucked by the Commonwealth. We both were fucked from the previous prosecution. We both were fucked by Canton PD. We've all been getting fucked. Like, we're on the same side here, right? You guys see that? It's like that whole thing of, like, if you have the same enemy in common, what is the saying? There's a saying about that, right? There's a joke that they make, I think, in The Office, TV show The Office, about everybody hates the lunch lady, so then they all join forces or whatever it is. But, similar thing. We're all fucked by the Commonwealth. I think it's really accurate and smart. But also this question here, right? If everything is deleted, why is anything being found? It looks like that has to do with that retired, unnamed, what was he, a detective, a cop, whoever it was. I mean, it seems like, I mean, there's only one of two possibilities. Either everything wasn't deleted and the whole 30-day thing is a lie. That's one option. Or the other option is that's true. However, this other dude was saving it on his personal hard drive and has it sitting there and for years and just decides what to do. Like, I don't know which is worse. Probably the second one, honestly. It's bad either way, but those are the only possibilities here. So exactly. Giving him an out. Very astute. Yep. It's not too late for him to back out. I would think. I mean, I don't think they can, that's the other thing, right? Think about like in Baldwin, right? So, oh my God, or Linda Johnson, right? Think about in Baldwin. So she was brought in as a special prosecutor, just like Carrie Morrissey, right? And the thing is this, right? When Erlinda Johnson saw the fuckery and the Brady violations and all that, she did the right thing. And it's not just doing the right thing. It's required as per the American Bar Association model, the rules and the code of conduct that they have to, if they see fuckery going on, especially when it comes to things like exculpatory evidence, like they have a duty. And in fact, it's not just it's like, if you participate in that, you can lose your bar license, right? Sanctions, but like more than just sanctions, right? And like you have a duty to report these things. You have a duty to not participate in it. And if you do participate in it, bad things. And so that's just to this end, giving him an out is very astute point because, if Mr. Brennan, it's risky, it's just risky. And it does make one wonder, is that partially why they brought in another person who doesn't know? I mean, I don't know. Like, obviously it wasn't working as it was before. And, they tried to bring somebody else in, but you could also think like, well, by doing that, by bringing in a special prosecutor who doesn't already know the history, is there almost a plausible deniability so that they're less likely to get into these issues where they have a responsibility to make things known and to, I don't know. Do you guys see what I'm saying? It's like all the secrecy within the office, right? And they all kind of seem to know what's the different levels of secrecy. And then they bring in a new guy who doesn't know. So then he can't accidentally say what it is, right? Sort of like with think about like these different cases where there's like a hitmen involved, right? What's the point? Well, separation of powers. You want to make sure that the hitmen have no idea who hired them and who the person on top is, right? Because the idea is like, even if they do want to tell all, they can't give the information because they don't know it. Similar idea, right? You bring in somebody new and just hope they don't discover some of the shit. And then it's like, well, then it's less likely to come out into the open. I don't know, just thoughts.
Chief Rafferty, and she said, with no hesitation, yeah, bring him on out here.
I mean, it doesn't make any sense.
Had anything to do with the fact
totally agree.
There was no data on the DVR. You can look all you want to. The bucket's empty. I have no idea about this iCloud account or who owns the iCloud account, why this data on January 29th was moved from the DVR to the iCloud account. Mr. Brennan did say, do you want to have your expert come back out and watch as we download the iCloud account? And I said, let's defer that because this is literally these are the contours of motion that's going to be before the court. And I still want to defer it because what I didn't want to do is pay another $12,000 or $15,000 for a second bite at this apple just to find out that iCloud account is somehow compromised as well.
Can you have someone record it? Can you have somebody that won't
This
cost
is a
you
good idea.
$12,000 if you want to come out and just have someone record it as it's being done?
Sure, I didn't interrupt the court. Yes, I can certainly make accommodations other than flying an expert out and having somebody do it in person. That may be an option that we exercise. I may talk to Mr. Brennan about that because I still want to have some transparency on that process.
Yes, that's it.
What I don't
Thank you,
want
Scott.
is to spend to throw
Thank
good
you.
money after bad at this issue when
Separation,
she's already spent
separation.
$12,000, $12,200 and something
Thank
for
you.
absolutely nothing. This is not a matter of courtesy. This is a matter of obligation. This was a matter of Brady. It's no different. By the way, the case that Mr. Brennan cites, he indicated that I cited that case. I didn't cite that case. Justice Gaziano cited that case in his opinion in the committee case. And the ultimate opinion of that court was when there is a discovery violation, when there is a Brady violation, and there is no question that that's what's before this court. Blatant discovery and Brady obligation, Brady violations. The Commonwealth doesn't. The court may
They're
remember-
probably just hoping he wouldn't discover some of the shit, right? But he's not in. The thing, he's not in on the secret. He's not from the local club, the local crew, as it were, right? The boys' club or whatever. You know, I'm referencing other things there, like you know, that's the good old boys' club is kind of how they talk about it in Murdoch. But anyway, he's not a part of that, right? And so, yeah, I wonder if that was part of that strategy.
By the way, on the witness stand, when these videos were coming in piecemeal, especially the inverted video, 2 or 3 witnesses all went like this. I wasn't the one told it. I wasn't the one that downloaded it.
Speaking of the 7 degrees of
I wasn't the
separation.
one that downloaded. I don't know where it came from. It just ended up on my desk on a flash drive. I don't know where it came from. Everybody was pointing fingers at everybody else.
Yeah.
Nobody could establish a single chain of custody.
There. And that's what I said. That's what I said. Chain of
So
custody.
Chief Rafferty's statement, yeah, come on out. No hesitation whatsoever. They can come look at it. I suspect it's because she knew it wasn't there. This was we were led in a circular runaround. And it was ultimately at her cost. And that's what.
So didn't the two of you, when you talk about good lawyering, didn't both of you agree that it was highly unlikely it would still be there? Or are you saying that part's not true? Mr. Brennan told me
That's
that.
really the point
I
here.
said, I'm concerned if we don't get out there fast. I don't know what the override protocol might be. So yes, I was
Yeah.
concerned, but
I think right there, that's why they might, again, I'm not trying to do any spoilers, potentially might lose this because that's the point right there. Let me back it up. That's really, you know,
Good lawyering. Didn't both of you agree that it was highly unlikely it would still be there?
didn't
Or
you
you
both
say-
of you agree it was highly unlikely it would still be? Remember, the point of the whole thing of the defense's motion is that they were misled. They were told for sure it would be there and then it wasn't there, right? So it's different if they both were in agreement that we don't know, it's highly unlikely it won't be there. That's very, very different.
Saying that part's not true. Mr. Brennan told me that.
I said, I'm concerned if we don't get out there fast. I don't know what the override protocol might be. So yes.
Now, I appreciate what he's doing there because he's not going to flat out lie if it wasn't the case. Like if what Judge Bev is asking, if that's really what happened, he's not going to flat out lie and say, no, we were told definitively or whatever, right? So I appreciate that. But what I'm hearing from him here is kind of a middle ground, if you will, which is, let's listen again to his answer because I want to talk about that.
I'm concerned if we don't get out there fast. I don't know what the override protocol might be.
Okay, middle ground. Here's why. I'm concerned if we don't get out there fast. I don't know so that's sort of like not wanting to fully agree with what Mr. Brennan is saying, but how to put it. The thing that the reason the reason I feel like he knows, or he's in his mind kind of conceding that what Mr. Brennan said was correct, but he doesn't want to say that because he doesn't want their motion to be shot down, is because this doesn't actually make any sense, right? Because he's of the belief, right, that their override protocol is 30 days, right? So why this doesn't make any sense, which is like then why the override protocol might happen years after the fact and just be coincidentally overwrite something. And the other thing is this. The other reason this doesn't make any sense as an argument is because like you can't argue both sides of the coin, right? The fact that only bits and pieces of this video are coming out and not all of the video shows that right there shows you that it exists somewhere, but that it wasn't entirely overwritten, but that it's not really findable at the police department or whatever. Like, am I making any sense? Like in other words, it's not really believable to me that he's thinking, oh, maybe the video will get overwritten right now. Because if that was the case, that means the whole video exists in its entirety. And everybody's in agreement that that's not the case, right? Does that make sense, guys? Yeah, for sure. So like, in other words, the expressing concern that the video exists in the police department, but now it might get overwritten. I don't believe that because of the fact of how it hasn't been discoverable and the video is coming out in chunks and it's all messed up and inverted and all this stuff. Like, so I think he's trying to save the motion, but I think that what we just witnessed in this exchange with Judge Bev's question and his answer is going to give us some insight as to what's going to happen with this motion.
So yes, I was concerned, but who cares? Well, that's no legal moment. What I thought and what Mr. Brennan and I discussed.
And then who cares? I think he's lost it right there, right? Because I appreciate that he's not trying to lie and say that's not what happened, right? He's trying to be honest, but also save the motion. That's the right thing to do. But right there.
Has a self-executing obligation to provide that information to us because it's Brady. They also had an obligation pursuant to Mr. Yannetti.
He's switching the argument there, right? Because that's a whole different thing. She's asking point blank about were you told definitively it would be there? Because that is the heart of their emotion. And again, I don't blame him for wanting to switch gears again, because if he's not, which he's not flat out coming out and saying now, yeah, we were told that it was going to be there. So,
It's demand, not request, but demand to maintain that information.
So where is that demand? Is that in the file? Where is that demand?
February 2nd. I don't know what the docket number is. It was filed on February 2nd after arraignment.
Here?
Wherever the arraignment was, Mr. Yannetti.
It was in the Stoughton District Court.
Okay.
But it's part of the case file. And it stays with the Commonwealth, and that obligation stays with the Commonwealth. But I would propose to the court that even if the court's concern is, well, when was that filed? And did Mr. Brennan actually...
I haven't seen it. I know it's not part of our file, and you're talking about it as if it were here.
Your Honor, I can't say with certainty, but I believe that it may have been submitted as an exhibit to a previous motion, probably early on in this case.
Okay, I just wanted our record to be clear. You're talking about Mr. Yannetti filed this. You did not file it in this court.
I may have filed it as
an
exhibit,
attachment, but it was never any...
Right. There was, I don't mean to cut off the court, Judge.
It was never brought before me or a judge who had this case before me to be heard.
So there was early on, and so many motions have been filed in this case, but early on, I did bring a motion, I believe before Your Honor, asking that all of the Stoughton
not longer, not
motions that I had filed at arraignment and thereafter be ratified by this court. That is in our record.
So I need you to find that.
Happy to do it.
And tell us when it was filed. I need to see.
By the end of the day today, you will have whatever submissions we provided.
At the end of the
if it's
day.
not part of an exhibit, you will have that motion.
All right. Go ahead,
Just
Mr. Chair.
to answer that one question that I can't answer because I've seen the filing. It was filed February 2nd, 2022.
Yeah, agreed.
My point is, even if that weren't the case, and it is the case, the obligation is self-executing. That's what Justice Gaziano was talking about when he talks about in the committee case, the self-executing duty that a prosecution has or a prosecutor has to maintain and preserve exculpatory information and provide that information to the defense.
That is a very fun
they
fact.
led us to believe every
you got
single
out of
sign and signal, irrespective of what Mr. Brennan did or didn't actually personally know. The Commonwealth's conduct in this case, from the beginning of the investigation to now, suggested that information existed, the DVR existed.
Again, I love this. He's saying, regardless of what Mr. Brennan did or did not know, the Commonwealth knew this existed. Important distinction. And I think it's smart. I think it's really smart that he's not trying to go, again, scorched earth on Mr. Brennan. He's like, no. That fire goes to the Commonwealth. And, yeah.
Sorry,
I'm joining the good side, Mr. Brennan. You know what I mean?
We were going out there to know.
I'm joining the good
should
side.
have had to jump through this hoop and go on this wild goose chase at Miss Reed's expense. It is not. I think we can all in this courtroom agree. None of this is our fault. We didn't do any of this. It's all on the Commonwealth's shoulders. It's all their responsibility. They should have to pay for what happened when we went out there for absolutely no good reason.
All right. Mr. Brennan, I have just a couple of questions.
Yeah.
So you don't know for certain whether this information was in fact downloaded onto the hard drive, but you suspect it is based on your conversation with the named gentleman in your affidavit?
So there's two different systems. One's called the DVR, NVR. That's the actual system that keeps all the footage.
And I don't like that answer. Why? Because he's not answering it yet. Anyway.
Recorded.
That
has been
that
searched.
commonly is overridden every
Yes.
30 days.
Like has been overwritten.
Statewide police departments.
Yes, Your Honor. And that has been overwritten.
Okay.
And there is no information on that.
Okay.
So
When I spoke to the retired sergeant detective who had downloaded video, he said as a habit, he would routinely, when he would
Why?
make a video.
But like, why are we not asking questions about why the fuck does this retired? Like, who is he and why does he have it?
From the DVR, he would place it in a separate file. I can't say that it's exhaustive. I can't say that it captures all of the video. It's when he would make a copy. And it seems in this case, there were select copies made.
That's problematic.
It doesn't seem that there was
That's
ever a time when somebody just copied the entire event.
Gotta be kidding.
Now, the issue of whether there was a request
That's
for
even worse.
information of the Commonwealth, I think, is a separate issue. What exists on his hard drive in the detective file, I don't know. But what he's told
That
me
is not part of protocol. Just saying, that is just not. This is not. just to remind everybody, the feds are still doing what they're doing with this and all the other fuckery that's happening in related cases. Maybe we just have hope because they're going to be on top of shit like this. I mean, this is just not normal.
Routinely make copies of what he would provide to the court in the Commonwealth, or the Commonwealth in defense, and he would put on that separate file. I don't expect, and I'm only guessing, that it's going to be an exhaustive copy of the entire night of January 29, 2022. I don't expect that. I expect it will be a copy of whatever it is that he's provided in this case. And so I think before it just lingers there forever, it should be copied and it should be provided to the defense.
All right. So I do want you and Mr. Jackson to talk about whether within the next week you do have somebody video it, or your expense, you send somebody out at it, but let's get moving with that. I know you said you'd make download a copy and send it. Are you satisfied with that, Mr. Jackson, or do you want to have someone there while that occurs?
I at least want to noodle on that for a second, but I'll talk to Mr. Brennan about it.
All right. I'd like it done within the week. The person has to be there within next week, or the Commonwealth will download it. We've got to get this case moving, and you want it, so it's got to be provided.
The stall isn't my fault. Yes, we want it. That's why we asked for it in the first
Yeah.
place.
So let's try and work it out before you leave here today. Okay.
Sure.
All right, I'm prepared to defer the defendant's request. I'm prepared to do it now. If they want me to wait, they want to have somebody there, I'm receptive, but we're ready to do it now.
All right. So I'm telling you to please wait, work it out, but no later than next week.
I understand.
All right. Thank you. Did you want to be heard further? In
Briefly,
response?
Your Honor, although I've come into this case late,
I know, right?
and I assume all responsibilities of the government's case.
For real.
In the history of it. This motion is not about a Rule 14 complaint or a violation. If the defense has a
Yeah,
motion
I have it's absurd. It's just absurd.
to sanction
Yeah.
or to dismiss, whatever the remedy is, because they think they've been agreed, that would be a different motion. This motion is.
He's saying it again. You guys, he's saying it again. Isn't that interesting? Again, just to reiterate, the fact that he's trying to make the case for this particular motion, right? The motion to recover these expenses. He's saying this isn't warranted. This is, not what, there's no reason for this. This is an exception where, we didn't say it was going to be a blah, blah. But then the fact that he makes a distinction between what a no-brainer, right? In his mind, it should be to dismiss his motion, and then makes a distinction between this and the upcoming motions to dismiss. And he's doing this the second time is so interesting to me.
They're trying to get the court or asking the
Right.
court to impose costs because they had their expert come out at their request. And they were very clear about the risk associated with that. This motion should be denied. If there's a separate motion, we'll deal with that when it's filed. If I had
Again.
known that
Again. Huh. Interesting.
defense was going to argue something entirely different, and that is the failure to preserve, I would have made a copy of all Mr. Yanetti's motions and requests, and I would have provided them as an exhibit. But I did not do that because that was not the scope of this motion. This motion should be denied.
All right. Thank you very much. Taking this under advisement. And do not wait for a decision from me on this about whether or not you send somebody out to get that video.
We'll get started on that immediately.
All right. All right. So let's move on to the Commonwealth's motion for clarification regarding the search warrant, or the contents of the defendant's phone, more accurately. Please.
In reviewing the discovery in this case, I learned that there was a search warrant for Ms. Reed's phone. That search warrant entitled the Commonwealth to search for data that's outlined in what's known as addendum or attaches addendum A. Learning the history of this case, I further learned that because there was an assertion of
Again.
privileged communications, there was an agreement that the Attorney General's office would look through the data on the communications, and they would identify any attorney-client privilege information, extract it, and then provide the information back to the government of the defense. I am not sure of the accuracy, but I learned or read that the defense was given an entire data copy, forensic download of Ms. Reed's phone years ago. When I looked at the discovery, it surprised me that the Commonwealth did not receive the forensic data. It received a report. And when we reviewed the reports, it had references to navigation information and Google searches, but did not have any of the forensic download. And so clearly,
What?
the Commonwealth has a warrant, is entitled not only to the PDF extraction, they're entitled to the full force of that proof, which is the data. I spoke to my experts, and they advised that they believed that the data would have more information than simply a PDF.
Of course it would.
And so when I learned this, I wanted to both scrupulously protect the defendant's rights, but I also wanted the data for our review. And so I limited my request. to the data
Blows my
to-
mind that Lally or anybody else on the Commonwealth side didn't do anything about this until now. Like what?
Navigation information in the Google searches. Although I do not believe it was required pursuant to the communication protocol, I asked the Attorney General's office to engage in that protocol anyways, just out of abundance of caution in respect to the defense. I contacted the defense. The defense offered their objection. I think it has no legal merit whatsoever. They don't have standing at this point, but I noted their objection. I believe, without certainty, that the Attorney General's office has gone through that review to make sure there are no communications. However, they expressed some reluctance to provide the information because of the existence of the communication protocol, and they did not believe there was enough clarity that there was a distinction between navigation information.
Okay.
I do not see that navigation information, Google information, or the other data that I want is covered by the protocol. I believe that protocol has at least partially already been followed anyways. Time is of the essence. This case is on for April 1st. There is what I believe to be relevant material, important information, including Google information and navigation information that we are entitled to. I don't want delay. So I filed this notice so that the court could give direction, either assuring the Attorney General's office that they could provide the information, or
I feel like we got very little
be a protocol.
in the first trial with Karen's phone. Like there was like text messages between her and Higgins and like the phone calls, voicemails, but like, I mean, I don't know. There was very little data, I feel like, if memory serves.
Which I discourage, that it's expedited. If there is something the defense wants to look at prior to me receiving it, it should be on a very, very narrow time frame. I don't think they have a right or entitlement to review anything I get. I think the Commonwealth is entitled pursuant to the search warrant. If they have a remedy, it's after we've already reviewed it, not before. And so I'm doing this to facilitate things because I'm mindful of the April 1st file, and we will pursue this information and use it if relevant.
Okay. Is there an opposition? I don't have anything in writing.
Your Honor, not really. The only thing that we expressed to Mr. Brennan was, and maybe I misunderstood his first, there was a communication we had on the phone. I thought that he was seeking something far broader than the search warrant. It sounds like he's staying within the parameters.
It sounds squarely within the search
Right.
warrant.
So that doesn't bother me. I want to make sure that whatever information he gets is squarely, as the court just said, squarely within those parameters. January 28th at 9:30 p.m. until January 29th at 5:30 p.m. And otherwise, I don't disagree that.
There you go.
The search warrant can,
We all agree.
I'm calling it raw data, but I think we all know what we're talking about. Not the PDF, but the underlying data.
All right.
Yeah.
It's squarely within the search warrant.
Right.
Mhm.
I do feel Mr. Brennan did not have to come to me or even you with it, but I do appreciate that you did so. So yes.
Again,
So the AG's office
Points for
knows
Mr.
that
Brennan
you
on
are
that.
entitled
Points
to
for
that
Mr. Brennan
information
on
and will
that.
have it immediately.
credit where credit's due.
Okay. All right. So the motion regarding, just want to get Commonwealth's motion for reciprocal discovery pertaining to employees of ARCA. And then if you go one step further than that, are we going one step further than that with the second motion today? Or do council want to come to sidebar and tell me any information you have? Or how do you want to do
Sidebar.
this?
Whatever the court's most comfortable.
Drive the car to
Open
the
the door,
sidebar.
I'd prefer to find out what's going on over in federal court at sidebar first.
Yes, Your Honor.
Oh, in federal court. Okay, we're going to jump ahead. Horrible sounds, so we're just not going to torture ourselves with those. There's still a sidebar. There we go.
All right, so I will hear you, Mr. Brennan, on your motion for reciprocal discovery.
Your Honor, we're expecting to file a certificate of compliance this morning. We've provided voluminous discovery to the defense, and it is now incumbent upon the defense to reciprocate pursuant to the rules. I filed a motion to reciprocate. Also, there is a specific motion regarding expert witnesses relative to so-called ARCA experts.
So
Those
called.
requests are consistent with
Is there any doubt that they're from ARCA or they're
pursuant to
experts?
Rule 14, and we are asking that the defense comply if they expect to follow the witnesses to trial.
And you've asked for, you
Yeah,
have
they're funny.
specific requests for the discovery, right?
I do.
All right. Mr. Jackson,
Thank you, Your Honor. I appreciate the opportunity to be heard on that. I appreciate Mr. Brennan's indication
Okay.
that he intends to file the certificate of compliance today. We know what our obligations are under Rule 14, and we intend to comply.
okay.
Intend to
All
comply.
right, so the motion is allowed.
Okay.
And Mr. Jackson, you had a scheduling concern?
I do. Concerning we received notice of discovery number 58 last night. It probably, I'm guessing it contains between a dozen, maybe 15 categories of new information that we could get
Scheduling.
within that notice of discovery. They're substantial, including multiple experts, some individuals that we've never seen anything from. There, I believe that upon review and analysis, those some or all of that will be relevant to our motion to dismiss, which I think is going to be pretty full-throated.
Sweet.
The court indicated that it
Full-throated,
wanted
he
to
says, guys.
file our motion to dismiss, I think, by the 11th, which is in 6 days from now. I don't think that's a reasonable possibility. We simply cannot get it done that quickly. I would ask the court, urge the court to allow us until sometime the beginning of March. We've got several dates on calendar. I don't have them committed to memory, but we'll be back at the beginning of March. That motion to dismiss, I think, if we have the time to do it and get it filed by the beginning of March, it's not going to take an enormous amount of court time. The time that's going to be taken is our preparation of the motion. But actually arguing it and ultimately the court either taking it under advisement or deciding on it, I don't think it's going to be that burdensome, although it's going to be a very, very full-throated motion.
All right, so you first raised the issue, I believe, in a footnote in one of your other motions that was filed, I don't know, January 21st or earlier, that this motion to dismiss is coming. You had a motion to dismiss it, the last trial, the same thing, forecasted, and then it's coming, it's coming. I need that motion in order to get it heard before then. Let me hear what the Commonwealth has to say. What's the extent of the information that you provided today or yesterday?
In the most recent discovery,
Yes.
it was voluminous.
Okay.
We provided a number of expert witnesses, entire files of expert witnesses. We've been providing discovery in an ongoing manner rather than wait until the end. When I've retained an expert, we've notified the defense. When we have reports, we've notified the defense and provided them almost immediately. But there is quite a bit of information that we put together regarding expert reports and data information, accident reconstruction, phone investigations. So we sent it by link because it was extraordinarily large.
Okay. Does the defense anticipate evidentiary motions in this case? About time that maybe I can flip these. Do you anticipate evidentiary motions?
I don't anticipate evidentiary motions from our end. Obviously, if that changes, I'll let the court and counsel know immediately, but I don't think so.
How about the Commonwealth?
They're none expected.
Yeah, I know. I don't blame you.
Mr. Jackson, I'll give you until February 20th to file that motion to dismiss. And we'll hear it if there are no evidentiary. Commonwealth, I'd like you to comply with your response if you could by the 27th, 28th. Oh, wait, this is March. I'm sorry. No, February 20th. Yes, if you could have it by the 27th, please. And then we will have a hearing on it on March 4th. If there are any evidentiary motions, they must be filed by February 11th.
Motions to suppress, for example.
And I want you to talk about whether we have a voir dire of the defendant's proposed witnesses, because we'll have to do both at the same time.
Your Honor,
Right.
is it possible? I'm just looking at the calendar for the first time as the court's going through its calendar. Is it possible that I could urge the court to allow us the 24th to file a
Yeah,
motion?
I agree.
It's a weekend. That is incredibly meaningful for us. I don't want to hamstring the Commonwealth if they need until the 3rd to give them a weekend.
No.
Again, think about it, right? Again, very respectful to Mr. Brennan, right? I appreciate that. I appreciate it's like we're working together on certain things, and we can all agree that we're getting fucked by the Commonwealth. Come and join the good side, you know.
Possible?
But also, I need weekends.
Right.
So it's not possible. So I'm giving you from February 11th to February 20th. I'll give you to the 21st.
Okay, 21st. Thank you, Your Honor.
Commonwealth, I'll give you to the 28th.
Thank you.
All right.
So Judge, are we taking off 218?
We're going to take 2-8. Let's keep it on now. If you work out if you believe that it would be helpful after talking to do a voir dire of those witnesses, we've got the 18th free.
The 18th of.
February. You were supposed to be here anyway on your motion to dismiss.
Okay, I'll discuss it with Mr. Brennan.
All right. Thank you all.
Your Honor, may I?
Yes, I'm sorry.
So this is funny. He's got a couple last things. So did anyone catch? So I know she said the written motion for the motion to dismiss was due February 20th. Previously, February 18th is what I have written down was the motion to dismiss oral argument. Did you guys catch when she changed the day for the oral argument for the motion to dismiss? I can also go back and check because I like to write these down so I can have the dates in mind. But yeah.
A few things, housekeeping matters. One, I'd like to set a date for reciprocal discovery.
Yes,
There has been
yes.
a date sent. I'd like to.
All right. So you were filing your notice of compliance today. Do you have it now to file?
I do. Can I just
Okay.
show it to the defense?
Sure.
Yeah.
Oh, it's an extra copy. Okay. Awesome. Thank you. Can I hand this in, Your Honor?
I get it.
Thank you, sir.
But you should want the right person to pay. You know what I mean? Not me.
All right.
So MCAT, if you have to go, thanks for being here. I think it's funny because I think Brennan pops up another time or two with a last minute. Wait, another thing.
So all reciprocal discovery be provided by March 6th. All right. Thank you all.
One last.
Yes, I'm sorry.
There it is.
Can
Funny.
we come sidebar for this?
Sure.
Sidebar. And I don't think we hear anything else after this sidebar. I'm going to go back a second because, again, I don't think we hear anything else. I'm going to go back a second and see if I can grab that date for the oral argument on the motion to dismiss.
All right.
So Judge, are we taking off 218?
We're going to take 2. And I want you to talk about whether we have a voir dire of the defendant's proposed witness.
Before this,
We will
the 20th.
the 28th. If there are no evidentiary,
Okay.
I'll give you until February 20th to file that motion to dismiss. And we'll hear it. If there are no evidentiary. Commonwealth, I'd like you to comply with your response if you could.
No wonder I missed it because she doesn't like finish her sentence there. And we'll hear it. Huh? I guess she means hear it on the 20th as well. That's annoying. Good God. That's the thing everyone's going to be listening for, right? And it's like she doesn't fucking come out and say it.
By the 27th, 28th. Oh, wait, this is March. I'm sorry. No, February 20th. Yes, if you could have it by the 27th, please.
Okay, so I guess it's February 20th for the oral argument on motion, just because sometimes the day that they have to submit the written filing is different than the oral argument day, which is why you also have to double check. But Jesus Christ, could you be any more annoying, Bev? So let me just double check and make sure they don't come back after that sidebar, but I don't think they do.
We've got the
Can I hand this in, Your Honor?
The sidebar. And with that,
Mr. Brennan, anything else?
Thank you very much, Your Honor.
Mr.
okay.
Jackson, anything?
No, Your Honor, thank you.
All right. Thank you all.
Any other any more last minute pop-ups? Nope, that's it. Okay, so there you go, guys. Well, hopefully you guys heard how annoying that was, but it sounds like February 20th will be the motion to dismiss for oral argument and the due date for the written motion. And that, I believe, will be a Thursday. So we will, of course, be on the lookout for that. But now let's go to the order, Judge Bev's order on this expert related expenses. And, you know, you guys already heard me sort of say that there was that one moment where I was like, yeah, I don't know, because just have to share screen. It seemed like there wasn't, you know, if the defense was going to maintain that they were told point blank, there's a video, you're going to see it, it would have been different. But that's where I was like, yeah, because even Jackson conceded that point. Again, props to him for not trying to mislead the court. You know, that's one thing of many that separates him from the Commonwealth. All right, so here we go. So this was issued just like, I think, mere hours after this hearing concluded yesterday. Decision and order on the defendant's motion to recover expert-related expenses from the Commonwealth. After hearing and review of the pleadings, the court credits the affidavit of Special Prosecutor Hank Brennan, paragraph 6. Attorney Jackson expressed concern that materials may no longer exist on the NVR given the time that had passed since the event. I agreed with him and told him that I had no knowledge whether the materials still existed or were overwritten given the passage of time. In light of the averment, I don't know if that's supposed to be, of ADA Brennan, and in light of Attorney Jackson's acknowledgement, like I said, during the hearing, that he and ADA Brennan discussed his concerns regarding the likelihood of the video still existing, the motion to recover costs is denied. Further, though Attorney Jackson argued for sanctions in an alleged violation of Mass R. Crimp Rule 14, there's nothing in the written pleading raising this argument, and the issue is therefore not currently before the court tonight. I will say, this is a rare occasion on which I do think that, given what is said here and given what I just said during the hearing, I do think this was the right call, because again, they just didn't prove that they had knowledge of it and did that on purpose and all that. And, you know, the other issues regarding the discovery and the fuckery, again, that's going to be for a different motion. As weirdly, we heard Hank Brennan mentioned multiple times, like that's a different issue. Again, I found that interesting too. So, you know, most of the time, Judge Bev, from my perspective, is not necessarily making the right calls. You know, even her freaking order regarding Dr. Russell was dripping with bias towards the prosecution, completely unnecessarily. It was disgusting and off-putting. But this is pretty succinct, and I mean, I don't think she got it wrong here. That's probably one of the only times you'll ever hear me say that, for a fact. So yeah. So that's it for this one. That's the latest there. And yeah. So guys, I'm waiting to hear back from a couple students, and I may be going live again tonight with more Adelsons. So let me just ask you guys, my thought is doing Luis and Sigfredo, also known as Alfredo, doing their interrogations / interviews, doing that, and then also watching Luis Rivera's testimony during Katie's retrial. But if you guys have other things that you would like to see, just let me know. But that's my thought. Again, I don't have it like on the docket, as it were. I don't have it like scheduled, you know, because I don't really know yet. Like I'm waiting to hear back from people who are in different time zones, and they might still be at school or at work or whatever. Work if it's parents, school if it's the kids. These days I get text messages from both kids and their parents. So anyway, they're in different time zones. So I'm just sort of waiting to hear back, but potentially might be able to come back with another live stream. But yeah, as far as what it would be, I'm thinking it would be those two interviews and then Lewis at Katie's trial. However, as y'all have heard, I am not opposed to watching Wendy again at Katie's retrial, because that was fucking amazing. Totally not opposed. I understand if you guys were like, let's just wait a little bit because we just watched it, but I'm just saying. Wow. Well, we got a warmer day today. It's been going back and forth. 2 days ago, it was like in the 80s or something, 70s, 80s. And then it got back into the 30s again yesterday. Today, it got up to like 70, and right now it's 60. But I have, you know, it could drop again. That's North Carolina weather for you. And Scott is joining us from close to the border, but in Canada, my understanding. So yeah, stay warm to you as well, Scott. Bev's other car is a broom. Totally believe that for sure. It would explain why her hair never grows, right? Isn't that a thing? I'm pretty sure that's a thing. Her hair never grows. It never changes because she doesn't, the rules of time don't apply to her, right? The rules of time and space don't apply. Hilarious. So anyway, if you guys want to let me know, you can always let me know too in the Discord if you have other thoughts for what you want to see next for Adelsons, or you can always comment, of course, too. And, you know, I'm still putting together stuff for BK. As you guys know, I wouldn't be surprised if there's not some court filings. I'm going to keep an eye out because sometimes yes, we know court filings will drop at the end of the day on a Friday, and it's 3 hours earlier there than it is here. So in Idaho, it is still within court hours. So who knows? If we see something like that pop out, I might go back live with that if I'm able to, depending on my students. But I'm still working on all my map stuff, as I've been talking about, trying to make a thing with the maps where it shows all the stuff, and it's still a lot going into it. But anyway, I know I am lucky. I love the warm weather. I was very happy that it did warm up. I did see something too about another storm coming through. I don't know if that's supposed to hit here or not. By storm, I mean a winter storm, but it wouldn't surprise me if it drops back down into the, below freezing at any point in time. So, but y'all are awesome. Love you guys. Thanks for being awesome squirrel friends. You guys stay warm, stay healthy. Those of you guys who are sick, I hope you feel better. And love y'all and see you next time.